Asheville formed a Blue Ribbon Committee to study whether the city should adopt a new commission or how it should better advance justice within the city. This Blue Ribbon Commission decided that Asheville should form a Human Relations Commission and appoint to that board 6 African Americans, 2 Latinx members of the community, and then other members who have either a disability or they live in public housing, represent members of the youth in the city, or are recognized as community leaders. And so after that commission was formed, the city attorney actually informed the commission that such racial quotas were unconstitutional, and so that those needed to change. And so instead, Asheville implemented racial balancing preferences for the appointments to the commission. And they also added 2 additional racial groups. They added Indigenous or Native Americans, as well as Asian Americans, but they still endeavored to appoint based on race. We represent 5 citizens of Asheville who are very active in their community. We have one plaintiff who has worked for the city for over 30 years and involved in risk management and been a liaison with really all branches of the city government. We also have a woman who was a PTO president, another person who is studying social work and wants to be a social worker in the community. So they represent a wide variety of interests. Unfortunately, they do not have the race that the city of Asheville would prefer to appoint. Well, unfortunately, Asheville's racial-based preferences is still unconstitutional under the Equal Protection Clause of the 14th Amendment. Under that clause, the courts look at government rationales for laws with the strictest, most exacting scrutiny. And in order to justify the use of racial preferences that the Supreme Court has called pernicious and, is just antithetical to the Equal Protection Clause, the city must prove that it has a compelling interest and that it has narrowly tailored that law to achieve that compelling interest. And the city of Asheville can do neither here. Well, we're involved because we want to vindicate the right of individuals to be treated equally. Race is but an arbitrary classification that individuals do not choose. We are born with our race. We get to choose, our affiliations. I'm affiliated with Pacific Legal Foundation. I chose to go to UNC Chapel Hill and be affiliated with that university, but I didn't get to choose my race or my skin color. And so we believe individuals should be treated as individuals, and their experiences and their unique perspectives should be valued as such. My clients want to be treated fairly and equally as the Constitution and as morals, suggest that they should be. They want to be treated as individuals, and they want to have a fair opportunity to be considered for a board that gets to advise the city council. They want to be civically engaged, and they want to contribute to their community. If we win and are successful, then the city of Asheville will have to do away with these race-based preferences. And there are other narrowly tailored ways that the city can achieve its goals of including more underrepresented folks in their commissions. They can ask people on applications to detail how they have been left out of civic engagement in the past. They can ask people of their experiences with city government. But what they cannot do is boil individuals' experiences down to something as gross and arbitrary as their skin color. As always, Pacific Legal Foundation stands with individuals who are willing to stand up for their constitutional rights, particularly whenever the Equal Protection Clause of the 14th Amendment is involved. And I would just encourage all of your viewers to go to pacificlegal.org to find out more about our mission and our work.